My name's Bhudia, Chartered Quantity Surveyors. We're in northwest London, Stanmore. Work with the architects and developers predominantly and a few resi clients, homeowners. We obviously quantify price and tell you how much you're going to be spending. I'm going to be talking to you today about contract awareness because everybody's in a contract, either with verbally or actually formally. This presentation looks more at the JCT as well. Which is an industry standard contract. So let me move on. I think also in the slide decks, the presentation itself is quite small, so you may be finding it hard to read. But reach out to me if you want the slide decks. I'm more than happy to send them across. So this is agenda. Very quickly, I think there's a few key things I want to touch on here. That's your delay notices. Insolvency is one thing I want to touch on. I reckon we'll be seeing some contractors go insolvent very soon because of obviously where we're heading and uncertainty. So definitely want to make sure everybody's aware of what's going to happen and your procedures for that. And then obviously about just the supply chain and how many layers there are in it and how everybody interconnects. So a little bit about contract. So what is a contract? Obviously it's enforceable by law and it's just agreement between the two parties. You get various types of contracts. In the JCT, there's 50 standard versions. You can also have like the modified form of the standard JCT or any other form of contract. And you can have these bespoke contracts, which are just like a deed of agreement. You'll see that a lot written up by solicitors. And then the contracts are split effectively into two parts, the professional ones and obviously the ones for the construction works itself. The professional ones, I generally use the RSC standard forms. The REBA have a whole suite of their own set of contracts as well. But that's basically the two categories. Now, it is worth mentioning that oral contracts does hold a lot of weight. And I'm recently on a job where we've engaged with the contractor to start. We're supposed to give him a letter of intent. He received the letter and never signed it, but he was orally told to commence. And I think he's done about 200 grand worth of work so far. But now we're terminating him. But fundamentally, the contract was still there. We're still going to have to value and pay him that 200, regardless of no formal paperwork being placed. But it's good practice, just tidy everything up in formal paperwork. So why do we have a contract? It's obviously to make sure that every party who's involved in the works knows what they're doing. Their roles and responsibilities are set out very clear. They know what they can, when they're going to be paid. They know when they have to deliver. And you just have to have a contract in place so that everybody is really solidly aware of what they need to do. But also I like to think of a contract as not just necessarily a big document that goes in your drawer and just sits there. It's there to make sure that you mitigate any uncertainties. And examples are these where you've got a project and you just want to put contingency budget in there. That's just there to hold uncertainty against. I want to talk about the two types of contracts and how we sign them as a deed and underhand. Traditionally, as a deed is a 12-year contract. They'll be on the bigger projects. Underhand is 6 years. But just to give you the example of as a deed, I always like to think of it as the old wax candle where they melted on a scroll and they stamped it. And that's a 12-year limitation period. And I'll talk about that again later. Right, so this is why we have to have a contract and how the industry is so complex as I see it. The reason I want to talk about this slide is just to show you that every layer has to be tied into the next layer. And the new, not so new anymore, but the JCT 2016 really focused on this and wanted to make sure that the same T's and C's cascade down throughout the whole supply chain so that your subcontractors weren't getting stung by longer payment periods. And everybody knows that, like with Carillion's a brilliant example. They had payment periods, I think about 120 days or something like that with some of their subcontractors. And that really slowed down the whole payment process and damaged their subcontractors. So the 2016 version is really focusing on just making sure everybody's got the same T's and C's. Right, so these are some standard forms. Everybody knows a JCT. NEC I've used on a few occasions, not too much, but they're really good on big civil jobs. I like the NEC because it's very simple in its language, easy to read, unlike the JCT. FIDIC and ICC, mainly international forms and on bigger projects. But one thing I skipped over is the Federation of Master Builders. They have a really nice form of contract. It's quite simple. It's only a 2-3 page actually a 6 or 8 page document, but it's pretty well explained. So if you've got at small works and you want to just have a really simple short contract with your builder, look out for the Federation of Master Builders version. It's quite easy to use. So this is a very quick summary about 2011 versus 16. I went to a CPD on this recently, an hour long, so I'm not going to spend an hour talking about this because it's fairly boring even from me. The first biggest one was, as I said earlier, it's about cascading the whole process of from the supply chain, from the client going all the way down to all the small subcontractors that have the same T's and C's. So that's what they're looking there. They're looking at having the same payment terms, the same debt recovery procedures going all the way down. They simplified, those minor changes to loss and expense. There's nothing really to shout about there. But they did simplify the insurance bit at the end. I think it was quite complex before. But just touching on that, I see so many homeowners doing their works in their house and not actually getting insurance on their building during the construction works. It's a big risk, I suppose, if anything goes wrong. But fundamentally, it's down to the client to get, because it's their building. If they're doing a double-side rear extension, it's their existing building, they own it, they're just allowing the builder to enter onto the site to do the works. You have to have a sort of construction, an all-risk construction insurance there for the building itself, in case the builder does something dramatically wrong and obviously the building falls down. But I'd rarely see this on the smaller jobs, so if you ever are working on a small job, just make sure you're asking the question. I want to talk to you about this slide. It's a bit, I don't think you can see it very clearly in your packs, but this just shows you what you need and what professionals you need for each individual JCT as a summary. But fundamentally, a D&B, you have your employer's agent and no one else really. But I, as a QS, I still work on a D&B under the umbrella of an employer's agent, or as a specific consultant to the client. There is one thing also I love about the JCT, it's pretty much mute on ground risk. So they really don't have a strong enough process to identify what to do if there is a problem with the ground, if there's excavation problems, subsidence. So the JCT isn't the best contract when you've got a heavy ground job, but that's where you'd always refer back to the NEC. So contract admin. Now, I think we all do an element of this if we're on site, if we're running a job. Even as a QS, we may not be employed directly as a CA for the project, but I like to think that everybody has got a hand in it. You've got to get involved with just making sure the works are delivered on time, on budget, and just making sure they go smoothly. And just touching on this point, it's just about making sure you've got your right provisions in there, making sure everybody knows when they're going to get paid and what the payment terms are. What happens if you want to suspend works? So that's why I think you have to have a good knowledge of contract admin. There's plenty of books out there. There's plenty of notes in the JCT, but it's a big topic. So this is another change we've had recently, I suppose. It's the assessment of a loss and expense claim. You now have 28 days effectively to assess that. So once you receive your loss and expense claim from your builder, you will have 28 days to make an assessment. Now, on the 27th day, if you still feel you haven't got enough information, you're in your rights to ask for additional information, and that gives an extension of 14 days onto that. So that's just a time scale just to be aware of. So in the JCT, there's a whole book of notices. These are just some of the standard notices to give out. There's protocols behind each one of them. The one I use the most is obviously instructions. You just have to make sure the date is raised on them, who's it by, who has that actual design responsibility associated with that change. And also the time required to complete that element of work is quite important on an instruction, I find, because I've been in so many scenarios where we've come down to the end, it's the final account, and nobody's actually thought, hang on, these 100 instructions has a massive time impact onto the overall, but no one's actually calculated it. We know there's a time relevance against it, but as we're going along, no one's actually said it's going to be a week for that instruction 1, 5 days for instruction 2. So that's why I'm just a good advocate of just putting that on the instructions as you go along. So what is an instruction as well? It's a relevant event. So variations, adverse weather, civil or terrorism, failure to produce informations, delays on any nominated subcontractors, that would act as a relevant event. Delays in giving the contractor possession, and forced to measure, act of God. Going to go to the next slide. This one is obviously payments. Now, in the JCT, this is how it's stated in the standard form. The D&B is slightly different, but every job I get, I do this. I get my Excel sheet out, I'll put the date in when we started our first interim payment, and I'll just add in and make a formula in there that adds in my 5 days, adds in my due dates, adds in when the final payment's going to be released to the contractor itself. I'm not sure if everybody, well, that's not actually the word, but fundamentally it's the first date for payment should be 21 days after, sorry, let me start again. The first payment should be when you start on site, a month thereafter, and then 21 days after that, effectively. But I've seen contracts change where you can extend it. Go back to Carillion, they were putting 120 days total their period. But I'm currently on a job now where we feel that the contractor isn't strong enough financially, doesn't have enough cash flow. So we've cut that down just to make sure his cycles are faster and then he's getting payment in faster. So on the left is the dates. Now in the JCT itself, these are the 4 key dates which are stated. This is one problem of the JCT. It doesn't refer to a program or a Gantt chart. It's not specific enough to that. You can have a Gantt chart as a listed document within the contract itself, but very rarely do I see that. And in fact, if I ever do see that, I normally strike it out because I don't want the builder to be tied down to a Gantt chart to say that he has to install his bricks on this day and this has to be completed by that. Fundamentally, we want to know when it starts and when it finishes. Everything in between that, how he delivers it, is his protocol, is his risk, is his intelligence to make it work faster. And things change so often on site. You know, it's weather different. It's if your subcontractor can't make it, you may have to push things around and jiggle things about in the program. That's why having a Gantt chart isn't the best idea as a contract document. But the 4 dates here, base date, you would stay in the contract, and that's basically the day after that, any changes in regulations, building regulations or government statute. So if I say the base date today is the 1st of November, if on the 2nd of November I get a change in the fire regulations, that doesn't actually apply to this contract because the base date was signed on the 1st. So that change in the regulation can then actually act as a variation to the contract. That's fundamentally what the base date is saying. It's giving you a cut-off date for when regulations and anything thereafter that actually makes an impact onto the contract itself. So the whole thing about Grenfell, we know there's going to be changes in the fire regulations and changes in the building control. We'll see that impact onto contracts signed thereafter. So if I was smart enough and I'm signing up and I know the date for the building regulation is going to change next month, I'm going to make sure in my contract that I'm signing today, I'll be putting that base date 2 months down the line. So I've got the new change in the regulations within my contract. Date of possession, obviously the key one. And something else that ties into this is the deferment. We'll talk about that later. PC and your end of defects. So program, as I said, issuing a Gantt chart is a powerful tool, but I think I want to see these Gantt charts in construction programs. I want to make sure that I've got these points I love seeing on the Gantt chart. I want to make sure that contractors are showing me any long lead-in times, any production allowances they have. We're going down to a lot of off-site manufacturing now, and that's going to have a real impact into our days we're spending on site, what we're actually writing into the contracts. So let's see how that rolls out. Just going to go on. So as I was talking earlier, you've got underhand and as a deed. So the defects period sort of ties in with this as well. So a latent defect is something we don't know. It's hidden. So a latent defect could be if your concrete has been poured in a frosty conditions and it ends up cracking. It's something you can't see in your footings until your building potentially fails. So as a deed, where you sign it and you've got a 12-year warranty effectively against the building, you're then liable for that if you sign a contract as a deed. As underhand, you're only really liable for those 6 years. So that's the key difference and how it relates to a latent defect. Patent defects, obviously they're ones we can see, cracks in walls, hinges, doors, anything failure. And that's where your defects rectification period comes in. You have your either 6 months or your 12 months. I've seen some contracts have 24 months. But just be careful how, if you're doing a sectional completion, how this will then affect that element's rectification period. So rectification obviously happens as soon as PC is issued. So the effect of that is your insurance then terminates and the insurance then gets passed on to the client. The client then becomes responsible. No damages are then applied thereafter at the end of PC. And the rest are there really. One thing though, partial possession. So in the contract, we can always have sectional, and we always write that down if we envision there is going to be sectional. Partial becomes a lot more difficult when you're on site and you want to hand something back over to the client in advance so they can start using it. But partial isn't stated in the contract. It's not agreed up front. So the difficulty is when you're on site and you're having to agree an element you're giving back to them. That element then, it has to be agreed. You have to talk about access to that. You've got to then sort of section that element off for its own insurance purposes. You've got to value that element. So that element has its rectification period starting at that. And you know, so for example, if you're holding 5% retention on the project and and the overall project's £1 million, but you're giving £500,000 worth of work back to the client, then the retention of that £500,000 and that defects period starts then. So you're going to have 2 times when you're going to be giving full retention back to the client and half retention, obviously. So that's just one thing about partial possession. And it's also very tricky where you're giving partial possession to a client where they still need access through that work elements as well. I had that recently on a school where we had to obviously give partial possession back to the school itself, but it was going through our work elements. So all we did in that scenario is actually create a corridor for them out of Cordex and just protected that whole section. So at least those elements which were done and completed weren't damaged. But it was very tricky in that scenario because of the whole insurance procedure, because you're having kids live going through site and it was just it was a nightmare. End of the day, I say avoid partial possession, but you never have the option sometimes. Okay, so there's some further conditions within the contract. Obviously just mentioned about partial possession. Liquidated damages, you have to calculate them and have a logic behind them, why they're going to apply. You can't just throw a number at it. I used to have a massive problem when I worked at Ealing Council where you'd be giving schools possession back. But if you didn't give them back if you didn't give or deliver the building at the time they needed, you were stuck with 120 kids on the doorstep trying to get entry into the building. They can't. So the damages on there were astronomical, but you could never apply them on a building where the works were only £50,000 because it wouldn't be fair to the contractor to sign up. So we sort of came up with an own calculation based on the value of the work to apply damages. But more traditionally, a lot of our developers are doing them based on rental income they're losing, or financing the additional financing they're having to pay. So we try and calculate them into our damages. And then obviously the same effect with the partial possession. You've got to allocate there's a relevant amount of damages to the partial element. So we've got loads of bonds in the industry. We've got performance, advance, rectification bonds. To be honest, I only use a performance bond. I haven't ever used tender bonds, rectification. I think each bond just adds an extra cost into the job. I'm at the moment trying to agree a job with, or going through the contract stages, and the contractor turned around to us at last minute saying he can't get a performance bond. And that was a big red flag to us. He was giving personal guarantees, and we were getting that written by the solicitors, but the personal guarantees weren't strong enough, weren't for the amount of works we were doing. So fundamentally, we didn't use that contractor, and now we're back to the drawing board with a second contractor trying to negotiate them. But they've also not even giving us a bond because they don't want to add that to the cost, and they're giving us a 100 grand saving in order not to give a bond. Instead, they're going to give us a parent company guarantee. But to be honest, a PCG is only worth the value if the company you're giving it is a big company. So, you know, a big construction companies will give you a good PCG. I have this point in here, reasonable skill and care versus fit for purpose. So the JCT has reasonable skill and care. It's too ominous to put fit for purpose. That word, I think, has been used too often, and it's a very demanding word. It means you've got to basically deliver exactly for what the client does. And I've, a long time ago, I was working on a police station where we're having a big argument about where the electrical points were, the heights of them. They weren't designed for the use of the security guards, the use of the building. They were too high and they're too low in all various elements. And long story short, they were arguing that the building wasn't fit for purpose, and they denied giving us, as a contractor, they denied giving us practical completion. And that's just on a very minor point, but their whole, because it's a DMB, they're using that fundamental argument just to delay our completion, not release retention, and keep us on site to just keep muggling along and on minor snags. But if you look at it the other way, reasonable skill and care, it was done with reasonable skill and care. It was done to standards. It was done correctly as a contractor's opinion. So it's just, I'd always try and avoid the word fit for purpose. It's too onerous. So the control of the works. As I said, everybody should be trying to control the works. As a quantity surveyor, I'm trying to go around and making sure that works are done accordingly. I don't have the best construction eye, but I know when something's done right and something's done wrong. But I think everybody has to play a part in control of the works and just raise it up the line. So payments, we talked about that earlier, but when I'm doing a payment or doing my interim valuations, this is basically the headlines I have. So just trying to say, I always try to value the materials on site, off site. It's very difficult sometimes valuing materials on site because a trick of the trade is the contractor will bump that into the measure. The measured works he'll uplift, and it'll also double count on the materials on site. Can't really avoid some things. Provisional sums in the payments certificates. I always like to comment against how many provisional sums are outstanding and how many still are to be defined. I always like to note my variations instructed, just so that it's, once again, it's housekeeping. And the other one I like to do is foreseeable variations. If I know that something's going to change in front of me on the building, or there's going to be something coming up, at least I'm bringing up an early warning and raising that with the design team and the clients. And the final one is extension of time. I like to note that down as well in my payments. Just making sure that anything is noted, even if it's a second payment cycle, just noting it then and there. So at least everybody's on the same page and we can try and work our best to try and mitigate that as we go along the line. So, as I was saying, insolvency. I recently gave a very similar lecture to an architecture practice, and luckily I was with a gentleman who's going through his part 3, and he actually just took over this slide, and I let him. But the point is, I think we're going to get this very soon. I really see like we're going to be moving next year, and we're going to see contractors struggling on site. And I tell you why, because at the moment, a lot of our deal flow is with developers and architects. We're at that planning stage. We're looking at pre-construction elements. I had 2 calls a couple of weeks ago with big main contractors, just calling me up saying, Jay, we've got nothing in the pipe drive, nothing coming up that's really meaty enough for us to send all of our teams to. And I was just thinking, oh, that's going to be quite an interesting scenario, because fine, there's nothing actually happening on site. Next year, it's all going to kick off post-March. You're going to have a lot of builders on site with a lot of demand against them. I'm not sure if everybody's going to be able to meet or actually achieve the construction demands next year. So I just want to make sure that we're managing these sites well. And if we do see somebody going insolvent because they can't cope, these are the protocols I suppose to use. And even as a builder as well, it's value to know what's going to happen. So, simple steps: secure the site, secure all materials on and off it, get that valuation done on that day. Really lock down that site. Don't allow anybody in or out. In March this year, I was working for a developer, and the main contractor went bust. The main contractor had all of his subbies tools, all these toolboxes, all left on site. Luckily, the developer was kind enough to allow some subbies to come back on and get their plant and stuff. But one of the fenestration company in this scenario, I think they were the worst off, because they basically had some tower cranes, some lifting equipment, all on site, which was hired from HSS. And they weren't allowed to actually go onto site and claim and take those materials off and off-hire them. So I think they're still probably going through that, but the liquidators are involved. But that's the key of actually securing the site, making sure that whatever's there is locked down and you don't allow anybody on. Check your wording, your contracts, and obviously go into advising the contract administrators. And stop payments straight away. So, site meetings. Some of our sites, as I was saying earlier, we do a lot of pre-construction work. 80% of our work is before we even get onto site. 20% is when we're on site. And when we're on site, we do either fortnightly, weekly, or monthly reports. And this is the structure I love to set down. I always like to say, from the cost point of view, I always like to ask, are there any day works? Are there any variations popping up? It's an opportunity for the contractor to put his hand up and raise anything if he feels. But this is basically my structure of our meetings. Hope everybody has their own format and they're running it as more efficiently as they wish. I've got another slide. This talks about VAT, obviously, in the industry, and a lot of homeowners and these residence owners, they always don't get that. They're going to have to pay 20%, and when the builder gives their price, 300,000, they're going to be stung with a VAT bill at the end. And so often I see, a lot of the builders doing part cash, part actual invoice. Yes, it works. No, don't do it. We're recently looking at a tender for a good director in the HMRC and whatever his job may be. But as soon as this conversation came out, he just walked out the room because he didn't really want to know, but he knows what's going to happen. All buildings have 20% VAT, and the exemptions are here. New build, I always want to talk about the disability changes. So that one's quite interesting. Recently we did a house for a lady whose son was disabled, and they built an outhouse at the back. All the ground floor doors were widened for disability access. She thought then she could get that 0 rated. It's actually not. It was only that element, which was very small, which was rated down. So you can get some exemption, but not 100%. I'm not an expert in this, but I always reach out to I can't even pronounce the name, but anyway, I always reach out to that consultant and they always give us brilliant advice. There's something else which is VAT excluded. When the building's vacant for 2 years, then you can have VAT zero rated, but you've got to prove it was vacant for 2 years. Obviously, change of use is the general exemptions. Just listed out some useful websites. A lot of our guys love the Design and Build wiki. It's quite a simple website. Any questions asked from there. And that's it. I mean, I may have rattled through a lot. I've done this in about a very short period of time. Last time I did this was an hour and a half because we were talking as we were going along. Everybody's asking lots of questions. But is there anybody that's got something else they'd like to raise or go through again? Up to you.
Can I ask about payment terms? You know, is this how you work? So
No, this is
7 days before the valuation.
This is the JCT standard form of contract.
Yeah. So 7 days before. 7 days before we receive it as contract administrators, we get the valuation to review.
Yeah.
We've got how long? Another 7 days to review it, and then we've got 5 days in which to certify it. Is that right?
You've got.
We raise the certificate, and there's 14 days before it gets paid.
Yeah, basically, so you'll get it on the valuation date. So that's day 0.
Yeah.
7 all the way up to 12, up to 21. So you have that whole time to review. But if you disagree with it, you need to be letting them know on day 16.
Yes. Yes. Yeah.
But I never get to that scenario. I don't really get here. I'm stuck over here at valuation date, and that's it. I want to walk on site and agree then and there because I don't want the admin of going back to an office and thinking yes and no. There's only a few occasions where my clients then disagree with it, and they say, no, Jay, it's this, or it's what they wish. But then in those scenarios, it's a big battle. I just want to agree up front.
Yeah. Okay. So one other question. Looking at the VAT exemption there, so on properties vacant, whatever, for 2 years or longer, am I right in saying it's 15%? Sorry, no, 5%. Sorry, yeah, that's right. So
it goes down 5.
15.
But I'm saying 5, but please don't quote me. I'm not an expert.
Yeah.
Really reach out to, I forgot his name, Sam, I think. They'll give you free advice. And I do that all the time. I mean, to be honest, I've told him I'm putting his name here. And I said, give me a slide. He wrote this.
I was trying to remember, because somebody asked me the other day, because when we did a scout hut for someone, they're a charitable organisation, we had a VAT exemption certificate which we showed to the contractor, which meant he only claimed the asking price without the VAT on it. But I was saying on a residential building, I was just wondering how it worked.
It's still 20%, and a lot of resi clients just don't get that. And they do the thing which you shouldn't do. You know, it's part cash, part payment. But you can't help that. That's the industry we live in.
Yeah.
I'm not going to look at any builders around the room. Really. But it happens. You can't help it.
Do you wait till the end and recover it all, or do you do it as you go?
It should be done as you go along, because we're all VAT, your companies, you're VAT registered. You know, you've got to do it in your quarterly cycles, so it has to be done as you go along. I suppose no, but then there's hang on. I'm not going to. I'm going to retract that.
Yeah, no, that's fine.
Because I've seen another scenario where they did everything at the end.
Yeah, you can do that too.
Yeah.
I wasn't sure which is the best.
No, I don't know the actual answer to that, but I know I've seen both scenarios.
Yeah. Okay.
One question about insolvency. If you are in a situation where you've got an insolvent builder, has the procedure changed recently in how you actually deal with it?
Not really. No, it's still the same mechanisms you're following.
Yeah.
It's not. The JCT hasn't updated it well enough to represent any to change it. The
Right.
procedure's still the same.
Right.
But the liquidator will come in and he'll know it straight away. You know, but I know the immediate action to take, and that's lock down the site. But it's,
I was thinking about the aftermath where the last one I was involved in was many years ago, but we notified the liquidator, went out with a specific tender
Mhm.
to 3 builders, and told them that when we get it finished, we'll let you know if there's any money left. That was a long time ago.
Really?
Is it procedure?
No. You still have to raise the money to pay. You can't do that. I know you can't do that. It's not fair. It doesn't sound fair to me. And I know the whole JCT and the whole Construction Act is trying to
We
be.
had money that was on retention.
Okay. And we're using that to pay the end builders.
No, what we did was we notified whoever needed to be notified, put together 3 a tender package, went out to 3 other builders, and used that money to finish off the work. Has there been a change?
No.
This is about 20 years ago.
Yeah, but in those scenarios, I'm normally seeing the remaining budget
Yeah.
is never enough to finish the works anyway. So I'm always seeing top-ups.
Yeah.
But I'm still seeing a very similar
Yeah.
scenario.
Could you just talk briefly about what sort of contracts you'd expect to see on, which generally isn't contracts, on small works, small domestic works, say 50 to 100,000, something of that nature.
Do you know the...
Builders give a price and the client doesn't seem to get any real contract as such. What do you think of these situations?
So you're talking more about where you get it's a small works and it's just a fag packet quotation by the builder. The client's at risk.
Well, what would you recommend for a client in that position?
So before I tell you that, I don't know how many phone calls I've had this year. I personally act as an expert witness in these cases. I don't know how many calls I've had this year where that scenarios happen where the builders come in, there's not enough detail there, clients overpay them because the builder says, I want 20, 20, 20, and that's it, it's done. It's a big risk for the client, massive. What I say is call a quantity surveyor up now and plug them. We're not worth the value on a smaller job. The builders know what to do, and they should be able to give the client more breakdown. I always say the better detail is the better protection. So break down that quote. But it's really difficult because builders won't. Some builders do, some builders just don't. There's the NRM1. You know how we used to have the SMM7? SMM7's been, well, how we used to measure. It's been split now into an NRM1 and NRM2. NRM2 replaces the SMM7. But the NRM1, Google it, find it, it's got a very nice summary of the headlines in construction. Substructure, superstructure, finishings. And I'd sort of, if you've got a 100K job, get the NRM and just portion money against it. So at least the client can then see how much he's going to be paying for plastering or the wall finishings, how much he should be paying for. Don't necessarily need a QS there, but you can probably budget money against that, and that's a start, I suppose. But a lot of the cases we see is there is no formal contract. The builder just given their quote in, clients agreed, and that's it, move forward. That's fine. As long as the key things are stated, your payment terms, when I should have this somewhere.
What did they base their price on?
The builders or the client.
What information?
So
what minimum information do you think should be given?
Drawings. Now we do a lot of
Works.
Yes and no. I mean, a lot of our residential jobs are done based on anything under 200. I think I've seen just done on planning drawings, and then very difficult. Based on the planning drawings, and then the builder's just listed out what he's going to do and what he's not going to do. I think the finishings element should always be excluded. Clients are always very fussy, in particular with sanitaries, flooring, carpet. I never want a builder to be pricing them into doing them. There should be free issue and direct supply by the clients. So it's tricky. Schedule if you can get it done, but the schedule, go back to the NRM1. Take the summary page from the NRM1. NRM, New Rules of Measurement. So that's the summary page, and they'll give you a high level, 3-page schedule of works.
There's sort of a JCT man of works contract, and there's an RIBA one which has come out there.
Yes. I actually prefer the Reba one, but
The Reba one seems a bit more
I think it's more detailed.
straightforward.
I think
small works.
It's easier to read. But then if you want a real simple one, homeowners contract for done by the JCT without, you can get the homeowners one without consultant and homeowners one with a consultant. So in terms where you have the builder and the client direct with no consultants, use the homeowners JCT version. It's like £25 online. Download it and buy it from Amazon. You can get it from Amazon, £25.
That's the homeowner.
Homeowners, JCT homeowners contract without consultant. Is there anyone else? Other than?
No more questions? Well, that was very fast, so we're ahead of time.
Oh right, okay. Sorry. I can. Anyone else? Any scenarios you want to pitch?
Actually, can I ask a question on damages, liquidated damages,
Mhm.
where there seems to be punitive? I mean, a figure may be inserted, but when would it be deemed to be maybe a penalty rather than damages?
The judges will look at that. It'll get to, if you're even talking that scenario, it always sounds like it's gone to court. The judges will have to weight that. The judges will look at like what the logic behind the calculation it was.
Yeah.
So go back to that school scenario that I was saying, where there was no way we could put apply damages to a subcontractor doing £50,000 worth of fenestration. The damages on there would probably, I don't know how much, I think it's like 150,000 a week just to house that many kids on an offshore site. It's the judge's decision.
Okay.
But the logic has to be followed. Every time we do a contract and I'm calculating the damages, I'll present that to the contractor.
Yeah.
I want him to agree. He's not going to sign the contract if he's not going to be happy with it.
Sure. So here, this is obviously this is a contract that I'm involved with, which there's been an overrun, and I mean it's not a massive sum. We're talking £1,500 a week.
Mhm.
The contractor's going to challenge that because he's going to say, well, what was the loss to the client essentially? But I mean, my view is that was what you signed up to. That's what's in the contract.
What's
So,
the contract value?
$500,000?
It's only 1,500. Is it a resi job?
Yeah.
How many months has it gone over?
Oh, so this is only talking weeks. This is like 8 weeks.
To try and get 1,500 for a couple of weeks is going to be a big battle. I was just say try and either give the contractor an extension of time so it nullifies any damages and come up with an agreement. But if the client's really pushing for it, then
Well, the client's reasonably ambivalent at the moment, I have to say. But, yeah.
it just sounds like a I don't want to. I'm just trying to negotiate out of £1,500 for a couple of weeks isn't really
Per
Well,
week we're talking.
per week. It's not going to be, if it's 3-4 weeks on £500,000, it's not going to be worth the headache of trying to chase it. And then also the backup and the proof to then justify why that contractor's gone over. Was there any Gantt charts being tracked and recorded as you go along?
No, there's programs, so it's pretty good. I mean, I find that quite strange. I mean, given that, you know, it's not massive sums of money, but nonetheless, the contractor's overrun. There was he's got
Technically,
no justification.
If there's no justification, no backup, you've got all your right to
Yeah.
to go after it and to take the money off. But
Well, I'm just saying that they come back and said they feel that it's actually we're being punitive. I think it's been quite reasonable, but
what's his backup for his if he's
just
given?
bluffing it basically.
Okay, yeah, then he's just bluffing it.
Yeah.
He's got no leg to stand on, really,
Yeah.
has he? But then you've got to also think the long term. Do you want them coming back after 12 months to do any defects?
No,
Are they even going to do that?
I think they're quite happy. Never see them again. But,
Yeah.
yeah. Okay.
There's so much money out there in that pot of rectification money, that defects money.
Yeah.
There's good jobs out there chasing it.
Mm.
Difficult jobs, but there's good money.
Yeah. Okay. Thank you.
Yeah, thanks. Any other questions? Okay, thank you, Jay.
Thank you very much.